the clock accordingly.
Yes, Your Honor. May it please the Court, I'm Sylvia Walbolt. I represent Ventas. As the Court has noted, its oral argument order provided that argument of any appellant would be deemed argument of
Yes.
all of the appellants, and with the consent of all appellants, I will begin.
Okay, and are you going to do the entire argument, Ms. Walbolt? Or
Well, we'll see.
somebody may jump up and say, but
They're here if they feel the need to speak.
All right, so it's 30 minutes total, you understand?
Understand.
Okay.
Understand. Thank you, Your Honor. This is an appeal from an amended judgment that was entered by a trial court to add the appellants to a judgment that had previously been entered against the defendant, THI. This was a fundamental denial of due process. This court has held in a host of cases, including Cornerstone, Synquon, most recently Griffith v. Slade, that a court cannot adjudicate the rights and obligations of a non-party to the claim on which the judgment was entered. Now, the appellant THI Holdings was sued and named as a party in this case, but it moved to dismiss for lack of jurisdiction, lack of personal jurisdiction, and was, with the agreement of the estate and by order of the trial court, was severed from the trial, and accordingly was very advertently not a party at the trial that resulted in this judgment. None of the other appellants were sued or served with process. None of them were named as a defendant. None of them were named in the prayers for relief.
And Ms. Houghton, that's not in dispute, is that correct?
That's right.
That's not in dispute, is that correct? That none of these defendants were ever served?
I think it's undisputed that other than appellant TH Holdings, that none of these appellants were sued or served with process. None of them entered an appearance in the case. They weren't served with pleadings. They weren't served with orders. And yes, I think that's undisputed, Your Honor, on this record. Nonetheless, the trial judge summarily added all of the appellants to the judgment that had been entered against THI after trial, purporting to immediately render them joint and several judgment debtors for $1.1 billion, for which sum let execution issue. Whatever the amount of the judgment, that's just not the way our justice system works. This court, the Florida Supreme Court, the United States Supreme Court have all held that a judgment may not be entered against someone who was not a party to the claim on which the judgment was entered. Any such judgment is void. None of the cases that the estate has cited in any way support what happened here. All but two of them simply deal with claims preclusion principles, which are raised in cases in which a party is sued in a lawsuit and alleged to be bound in that lawsuit by an earlier judgment. And none of those cases have anything to do with adding non-parties to a judgment. Now, the estate has also, in addition to those cases, has cited two California cases, one by supplemental authority that the court should have received yesterday afternoon. And those cases, as I say, are California cases, and they rest on a specific provision of the California Civil Code that California courts have over the years interpreted as allowing a court to add an alter ego to a judgment debtor to the judgment after an evidentiary hearing that establishes, among other things, and I'm quoting, that there is such a unity of interest and ownership that the separate personalities of the entity and the owners no longer exist. So the theory is, once that's been established, then they are one and the same, and the court is doing nothing other than correcting the name of the party on the judgment. And in the Relentless case that was cited as supplemental authority yesterday, there was exactly such a finding by the trial court after an evidentiary hearing, after a hearing in which the parties who were alleged to be alter egos had an opportunity to be heard. The appellate court said there was ample evidence that they were in fact alter egos, and that finding was not challenged on appeal in that case, nor, I should say, was there any suggestion by the appellants in that case that they had been in any way deprived of due process. So I submit that the California cases that the estate relies on in no way support what happened here, which is a trial judge adding non-parties to a judgment without notice or hearing at the urging of the estate. Furthermore, and I think very importantly, Florida does not have a procedure such as California does. We don't have a rule like Florida has that allows a non-party to be added to a judgment. And in fact, this court has consistently held that even a party to a lawsuit cannot be added to a judgment on a claim to which that party was not a named party, even when it's alleged that the party is the alter ego of the judgment debtor. And we've cited in our papers Langworthy and Associates, Shepard and Barquette, all of which so hold. We've also cited cases saying that Rule 1.540, which the estate has relied on, does not allow a non-party to be added to a judgment, nor does the rule allowing pleadings to be conformed to the evidence. But, Your Honors, even apart from all of this, these appellants, who are a very diverse group of corporations and individuals, were not alleged in the motion of the estate. They were not alleged in that motion to be alter egos of THI, the defendant, and that wasn't the basis on which they were added to the judgment against THI. Instead, the trial court added appellants to that judgment based solely on their settlement agreement with THI's receiver, court-appointed receiver. The estate characterizes that settlement agreement as saying that the appellants, quote, purchased the defense, end quote, of THI in the case, and authorized the receiver's appearance in this case as their, quote, nominee. And the agreement says no such thing. You will not find the word nominee in the agreement. You won't find anything else in the agreement that authorized the receiver to appear on behalf of appellants in this case, much less to represent them as counsel in the case. Nor will you find anything suggesting that the appellants purchased the defense of this case. The estate lumps all of the appellants together when it says that they purchased the defense of this case. But even a cursory reading of paragraph 9, which is the only paragraph of the settlement agreement that could possibly be at issue, that paragraph only imposes various defense obligations on 2 of the appellants. Paragraph 17, which the estate simply ignores, expressly exempts all of the other appellants from even those obligations, nor, again, contrary to what the estate says in its papers, nor did any of the appellants agree to indemnify THI for any judgment against it. One of the appellants agreed to indemnify THI for defense costs under certain circumstances, and none of the other appellants agreed to indemnify THI for anything at all. But most fundamentally, Your Honors, none of this has anything to do at all with accepting liability for a judgment against THI. Indeed, Section 9.1 of the agreement expressly provides that none of the appellants shall have any obligation to pay any judgment against THI. So contrary to the estate's assertion, nothing in the settlement agreement permitted the trial court to add appellants to the judgment against THI, much less to do so without notice or an opportunity to be heard. The judgment against these appellants is void, lack of due process, and should be quashed or reversed by this court. In doing so, and in order to avoid immediately returning to this court, we ask the court to make it clear that appellants cannot be added to the judgment against THI, and that the estate's motion to amend the judgment to do so is improper, without merit, and should receive no further consideration from the trial court.
Thank you, Ms. Walbolt.
I'll reserve time. Do you have questions?
None?
I'll reserve the rest of my time.
Okay, there are about 19 minutes left if somebody else wants to speak. Don't all jump up. Okay. All right, Appellee.
Good afternoon. Isaac Reese Cruz on behalf of the estate of Townsend. Here the judge followed time-honored principles, and I think Ms. Walbolt actually elaborated what one of those principles was, and that is doing nothing but correcting the name of the party on the judgment. That's a principle of equity that goes back, quite frankly, before 1848 when the real party and interest rule was first developed. Back then,
If I may, if that's the case, why not provide them with a notice? Why not provide them with an opportunity to be heard, as opposed to the manner in which it occurred in this case?
We did. And we believe we did serve them with process. We believe that we did, in fact,
How?
give them notice and an opportunity to be heard. Because the individual who was there, Mr. Hagwood, was their attorney. He was not the attorney for the receiver, and the record makes clear that he could not possibly be the attorney for the receiver in this case, because the receiver himself testified in this case, in the record, and I know the record's sort of choppy because we're dealing with appendices to a writ of prohibition, and then after the briefing, there's actually the record on appeal that has been taken up by the court, I think sometime in late October or November. But there was the testimony of the receiver and the corporate representative for the receiver at trial that there was never a claim made in Maryland in the receivership estate by the estate of Townsend, that he believes the claim's bar date passed, that there's no interest or claim that we've lodged, the estate of Townsend, against the receivership estate. He has no skin in the game. He has no ability to be here. He's a foreign receiver. The only way a foreign receiver can appear in the courts of the state to defend a case is under principles of comity. And usually that's extended when there's an interest or stake in that receivership estate. It's so you don't have to open an ancillary receivership. But in this case, he said, I'm not a Florida receiver. There's no claim against the receivership. So his only appearance in this case was pursuant to the 2012 agreement. That's what the trial testimony was. It was pursuant to a delegation. And I can point the court to precisely where it is that this language in the agreement exists.
That's what I was gonna
but it
ask
doesn't
you.
say he's the nominee
Well,
there.
well,
It's his testimony that
Okay,
says
Mr.
he's the
Cruz,
nominee.
let's because you're making these statements. I want to know precisely
Sure,
where
absolutely.
in the agreement does it indicate that, and if you could just direct me to.
And let me start with the briefs universally on this side suggest first that they have no nexus whatsoever to this litigation. that they're strangers to the litigation, that they have no connection to Townsend. And so I point out that on page 2, recital G of this particular agreement is actually directed at the estate of Arlene Townsend. It recites on January 29, 2009, the estate of Arlene Townsend, and then it goes so on and so forth and describes that. And in I, it actually mentions that collectively with these other cases will be referred to as the Wilkes litigation. That's important because that's how the term is going to be used when we go through the actual provisions. 3.2, assigned claims. This is the assignment. Now, the language of the contract is that the receiver hereby assigns to the settling third parties jointly all of the estate's right, title, and interest. Interest, that term, is not defined in the agreement, but it is used repeatedly throughout this agreement. And every time it's used to include the defense of THI, and in fact it even includes the defense of THMI in this particular agreement. Now I understand, Judge Casanueva, in the GECC versus Nunziata opinion that you wrote, you described and differentiated the agreement with respect to the defense of THMI because THMI wasn't a party to this particular settlement agreement. But nevertheless, the agreement does discuss the defense of THMI. For example, in 10.1, it says that the receiver's interests for purposes of this agreement are construed to include the defense of THMI. So whenever we see the term interest of the receiver, it deals with the defense of THI and THMI. For example, in 11.3, the duty to defend and the right to commence actions in the Wilkes litigation on behalf of THI and or THMI.
Let's follow that. Let's just assume for the sake, but where does in the agreement does it say that these petitioners collectively are to assume any liability associated with the present lawsuit?
It's true. This particular agreement, well, it's interesting. First of all, 9.1, which is the provision that Ms. Walbolt discussed, there is the attempt to exclude themselves from any liability. Say that they are going to assume indemnification for the cost of defense, but they're not going to assume any liability for any judgments that are imposed. Although when you read the clause, it's ambiguous as to whether it's liability imposed for gross negligence as opposed to negligence in the case. So there may not be punitive liability imposed, but there may still be indemnification for a regular judgment. It has to do with the way that this particular thing's drafted. But secondarily, Your Honor, she pointed out very clearly that we've misread this agreement because most of the parties here have actually opted out of those provisions. So they've opted out of 9.1, 10.1, 11.1 to 11.5. So they've opted out of the provision that says that they've agreed to not be liable for the judgment. It's our position that their actions in this court, and I'll get into it in detail, I know I have some time for this, that is what makes them liable here.
But I guess my point is, Mr. Cook, you're referring to this document, and you're taking the position clearly they ought to be parties in this case. And it goes back to, I guess, my question. Why not give them notice? Why not have them come in and make the pitch to the judge as to why they're not liable by this agreement? You make the argument to the court why they ought to be liable by that agreement. But basically, the rug was pulled. None of that took place. All that you see after a trial, you have the final judgment entered, then immediately, I think within a couple of days, an amended final judgment was, I guess it was a request to the trial judge that please, in conformity with the trial, enter this amended judgment, pulling in all these people. And I'm concerned about that.
Sure, and I understand your concern, and let me address precisely what it is that happened in the trial. It's not just this agreement. This agreement is the written conferment of that assignment, the assignment of the defense of THI, and I think very clearly one of the positions that they've advanced is they didn't actually purchase the defense of THI. That's what this agreement stands for, an assignment of the defense of THI. And that's also what the receiver's testimony was in this case below, that this was an assignment of the defense of THI. So these parties actually bought that defense. But the person who showed up at trial told this jury that he was counsel for the receiver, and the receiver was not a party in this case. What you're supposed to be reviewing here, I think, is the motion to alter or amend the judgment. That's what's been actually challenged, now that this has been converted into an appeal. And the standard of review is abuse of discretion. Would any reasonable person do what the trial court judge did here? What was the trial court judge faced with from the bench? What was his perspective here, both pre-trial, during trial, and after trial? Someone showed up, an illustration helps if I could. Someone showed up and said, I'm the receiver for THI. And that's what he was wearing, a mask. because in this case, he was not the receiver for THI. He's actually testified that he's the face of the defense, that he has no interest here. That's what his testimony is, that he could either show up being paid by them as their spokesperson, or they had the option of showing up and defending this case. They chose to have him show up as a spokesperson without ever telling the court, I'm the spokesperson, instead saying, I'm the receiver for THI. Why did he do that, Your Honor? And that was their strategy. Sure.
Let me understand. So you're basically saying that by virtue of they agreeing to pay for the defense, that somehow they are parties, they should be parties to this litigation.
It's not that
what you're
simple.
saying?
No.
Okay.
If you simply buy a defense, that does not necessarily make you liable. It's the use of the defense. The receiver who showed up had no interest in this case. He wasn't a party in the case, but he showed up and said, I'm the receiver for THI. In actuality, he wasn't there as the receiver for THI. He was there as the delegee or the nominee for these 16 parties. And the reason why they did it, and it's very clear, and some of this is in the record. For example, Mr. Hagwood, who showed up, was actually in the bankruptcy proceedings an expert witness for one of the parties here, Fundamental Administrative Services, for the value of the Townsend case with respect to a settlement agreement with the trustee. So they had him testifying before the Townsend trial as to what the value of this case was. Then they have him show up and defend this case, because their strategy was, if we have a receiver show up in front of this jury, that would help damage containment. They'll feel sorry for him. He's an officer of the court. He brings that gravitas to it. It's not unlike, and the analogy may not be a very good one, but once a law firm hires William Shatner to do their ads, and he comes in, he brings a certain gravitas, maybe not credibility, but he brings a certain gravitas to being in those ads. But what's required in those ads is the disclaimer on the bottom that he's a paid actor or spokesperson, that he's not an attorney. And here, they had someone come in and say, I'm the receiver for THI, when the receiver for THI is not a party, has no interest in this case. But they did it, and they told the jury that repeatedly. For example, in voir dire, as I quote in my brief, they have the receiver, or the lawyer for the receiver, say, it's a receiver who's here. Would you feel badly that that's the only one who's here? So they tried to make use of this cloak of authority in Maryland, when that has nothing to do with this case, in order to limit damages. Because this side of the room knows that in other cases, they're the third-party targets of proceedings supplementary by fraudulent conveyance, alter ego. In fact, some of them have already been found to have received those transfers, and there's an appeal in front of this court in one of the other cases involving that, a fraudulent transfer and a fraudulent conveyance. But what happened here is that the trial court judge, seeing what occurred pre-trial, during trial, the testimony at trial, said, I know who it is that's behind the mask, who's actually been here, and what the reason is why they're putting forward this particular defense. And this is the inherent authority of a trial judge. Those California cases deal with it, but this isn't alter ego. It's not the same as an alter ego, because an alter ego, the party that's in court actually is a party, has the right to be in court. That's not the case here. The receiver had no right to be in the court in the first place. So it was a ruse. And so the trial court judge has the inherent authority to make sure that its records reflect the truth, that they speak the truth. That's what these equitable principles rely on. Does Florida law permit it?
Disclose that the plaintiff below and the appellee here learned that there was a ruse in progress.
When we filed our motion to alter or amend, that's when all of this came together to us.
So the testimony all took place after the motion was filed?
No, the testimony took place.
During the trial.
It wasn't just the testimony during the trial, Your Honor. It was the pretrial position. It was the arguments of counsel. And in fact, it even went further with the closing argument of Mr. Hagwood in front of the jury. So yes, and in fact, the California cases deal with this particular type of issue. When should you raise a motion to alter or amend a judgment in this particular circumstance? Did you have to do it at trial? Did you have to do it the second that you learned what was going on? If this was the strategy that this side of the room adopted, we can go ahead and let that strategy play out. That's what they chose. That's how they chose to litigate this case. That's not the purpose of a trial. The purpose of the trial is to determine damages, not to ascertain who the true defendant is. When the same type of ruse was attempted in another case, which is cited in the briefs, the estate of Nunziata, the trial court judge in that case, Judge Campbell, struck the appearance of counsel and found that there had been a fraud on the court. In this particular instance, the court permitted the trial to go forward. It was defended on damages, and at the end of the trial decided the parties who are here, the actual parties who are here, aren't who they say they are. They're actually these 16 settling third parties. And that's what he did in correcting the judgment.
But that's after, I'm still troubled by that, Mr. Cruz, quite frankly. If that's the case, why not give them all an opportunity? Why not notice all of them? Because the way it was a cover letter to the judge saying no hearing is even necessary, go ahead and sign this off in conformity with what was presented at trial. Why not? Because the agreement that you refer to, I've looked at it. Quite frankly, I don't think there's anything in there that indicates that they should be liable to a judgment. But perhaps this would be precisely why a hearing needs to be done, so all that could be fleshed out before the court. So still, I'm still troubled by that. Where in the trial, where any evidence that you could present to me, any document, anything that tells me, confirms exactly what you said, that was precisely what was before the court.
And as I indicated to Your Honor before, it wasn't just this agreement. This wasn't the first instance in which the trial court judge was presented with what was going on here. He actually had the receiver's testimony pre-trial, and the corporate representative, the receiver wasn't present at trial, he sent a corporate representative who testified at trial that the 2012 agreement was why they were there. It was pursuant to that assignment that the receiver for THI was there. And that's the only way that this particular agreement functions. It's the testimony and this agreement that the trial court judge was relying on. Why did I choose to send the letter as opposed to noticing all of these counsel? It's just like, for example, I've got lots of cases with the same defendant in it. And in some cases they have one group of lawyers, in another case they might have a different group of lawyers. That doesn't mean that in the one case where they have one group of lawyers, I notice every lawyer that I've ever known them to represent in any
But that's
case.
different. You're specifically asking the court to add specific defendants, specific people, those are the ones. And I'm not concerned with the others. Other cases, I know that perhaps different postures, supplementary proceedings, we're not dealing with that. So let's set those aside and focus on this case.
In this case,
Yes.
the lawyer who showed up for those 16 settling third parties was Mr. Hagwood. If you notice the letter that I wrote to the court, that's exactly who I served, Mr. Hagwood. And in fact, Mr. Hagwood filed no opposition to my motion. He filed no letter, sent no letter to the court saying this motion is incorrect. He didn't reach out to Chambers, the record does not reflect, and indicate that he was not actually there on behalf of the settling third parties. That no, he's there on behalf of someone else.
But
So it's
wasn't
actually
there-
uncontroverted from the standpoint of the person who was there.
But wasn't there also presented to the court where there were a few attorneys were given copies of perhaps your letter or perhaps the proposal? I don't know. They received something because it's in the record.
That's right.
That
After-
reflects that they were asking the court, please don't do that. Give us an opportunity to be heard. So there's even evidence presented there's even something in the record provided to Judge Duran saying, hold off.
Well, certainly. We served the attorney who showed up pursuant to this agreement, pursuant to this delegation, and that's what the evidence was, and it was clear. And that's what we did, and that's how we did it. After that, of course, now we get letters from some of these other parties to the court saying, no, we would like a hearing, we'd like to have some sort of a hearing, we'd like to dispute this. But the attorney who was there, who was actually present, representing these 16 settling third parties, raised no objection. And the court didn't think that a hearing was necessary, clearly, based on how uncontroverted and how clear the evidence was that he had heard pre-trial, during trial. So now post-trial, when this motion said, this is what you should do, correct the name of the defendants that appear on this judgment, because the party who appears there is not actually who they purport to be. That's what he did. This is not like an alter ego. This is not like the traditional thinking of a successor in interest, where it's the unity of these two parties, or the party who's there actually has the ability to be there. We're trying to add a shareholder or an owner or director. It's not that. The person who actually appeared in court presented the defense for these 16 settling third parties. That's why he was there. It's the only way he could possibly be there under any right. And that's clear from the testimony and clear from the agreement. And so therefore, we think we comported with fundamental due process. And frankly, in the California cases, which aren't exactly analogous because those are alter ego cases, and this is not an alter ego case, but in all of those cases, the litigants do raise fundamental due process concerns because they say, oh, we just got added to a judgment and we didn't get to participate in the trial. We weren't served with process. And the California courts consistently have held that it is not a deprivation of fundamental due process because you were represented. The attorney who actually was there had notice, had an opportunity to be heard, and they were your attorney. Now, they're using a theory of virtual representation. One is not necessary in this case because this is actual representation. The party who was there, and in fact, in the agreement itself, it indicates that FAS is responsible under 11E for hiring the attorney. Now, the testimony went further because the attorney who went actually said, I'm counsel for the receiver, and the reason they did that is, as I indicated, to try to limit damages, to give that gravitas and credibility to it. But this is, at its heart, a simple case in equity. Now, the question's been raised, well, that's California law, not Florida law, and Florida doesn't permit this type of a procedure. But with all due respect, Florida does under Rule 1.530. 1.530G was added in 1962. It was an amendment to the Florida Rules of Civil Procedure. But what it's codifying, when you look at the code, specifically the language underneath that particular amendment, it was codifying equity rules that existed. And it's the precise type of equity rule that exists in California under 785, which is the section that's continually referred to in those California cases, which is the power of the trial court in equity to correct errors in its judgment. And that's precisely, respectfully, what occurred here. An error in the judgment as to who was named in the judgment to correct that party. And that's something that a trial court judge has had universally since before 1848 when the real party and interest rule was first developed. So
Let me ask you something.
Sure.
Help me out here, since it's, like you said, there's a fragmented record. The trial in this case that took place after the default was on the matter of the quantification of damages, actual and punitive. And if I understand you correctly, the person who testified was called during a trial on damages. Is that correct?
That's correct.
Okay. So am I to safely conclude then, in the pretrial order, there was no issues raised for the trial court to determine the status of either of the parties and the right to be in a representative capacity? There was nothing in the pretrial court order that would say that we might have a motion to substitute parties or anything that would alert anybody at that point at all that this would be an issue coming before the trial court?
That's absolutely true. And let me tell you why, Your Honor, why this is an issue. I understand your concern. Why didn't we raise this before? Why wasn't this put before the trial court? Because prior to trial, the pleading said Trans Healthcare Inc. It was at opening, or actually before opening, during jury selection, when counsel said, I'm counsel for the receiver. Not counsel for Trans Healthcare Inc., counsel for the receiver. So it's during the trial itself that this particular strategy was undertaken. The reason I say that...
Notice that, do the rules allow you any response to strike, to disqualify, or anything for counsel who's not a proper party representative there?
They might, but if this is the strategy that's been adopted, the rules also permit under 1.530 for us to substitute who the real party in interest is. So the point is, the testimony prior to trial alerted the trial court judge as to who actually could be a party in this case and what the circumstances were. But then at trial, someone shows up and says, I'm counsel for the receiver, trying to take advantage of that fact. And the trial court judge went ahead and ended the masquerade. And that's precisely the opportunity that this court has in affirming what the trial court judge is to not permit this to keep going forward, to continue to misuse the name of the receiver to try to cloak this with some sort of authority from a foreign court. That's not what's going on here. This is plain and simple the defense of 16 settling third parties. Now, if for some reason this court thinks that 1.530 doesn't provide the proper vehicle for this, equity certainly does. And that's where this particular type of a motion, consistently in other jurisdictions, has been permitted. And that is to prevent a wrong, to correct an error that's in a trial court order, because the trial court, of course, has that inherent authority. Another important, significant fact here, I think, is that the parties have differentiated themselves in the agreement. They've sought to be treated differently when you look at their briefs. For example, FAS not only paying for the defense, is not only paying for the assignments, but they've also affirmatively said and taken the responsibility in 9.1 to defend. They've taken the affirmative responsibility to be responsible for hiring counsel in 11E. And as we filed in the record, in our appendix to the response to the petition, but it's also in the record below, the privilege logs that were filed in this court, in the court below, indicate the extensive involvement on trial strategy. I mean, it was hundreds, literally hundreds, if not thousands of entries.
I
Where
guess, Mr. Good,
Yes.
The main reason that doesn't trouble me, as an example, let's just say your cousin was involved in a horrific car accident. Your cousin doesn't have any money. Out of the goodness of your heart, you decide to hire the best lawyer that you could find. And you are very active, making sure you get into strategy, attorney-client, all that stuff. Should you then be pulled in as part of the judgment? Isn't that the
But
argument
that's
that
not
you're
the,
making?
if that were the only fact, no. But that's not the only fact. And this is one of the facts to consider, is the involvement in the litigation. Because it's one of those factors about the control that was involved in directing the litigation. When you're paying for the defense, when you're hiring the lawyers, when the lawyers are reporting to you, when there is no right for the person who's there to actually be there in their own name, and they're there in a representative capacity for you, and then you're also, the privilege law reveals, involved immensely in the trial strategy, then yes. And those are the facts that the trial court judge was faced with. This is not a case in which there was simply the purchase of defense costs or the agreement to pay for defense costs. It's not a case where there's simply involvement in privilege or in work product or attorney-client communications. It's a case in which the person who was there, Mr. Hagwood, was not there for the receiver, which is who he claimed to be there for. And in fact, the receiver couldn't be there at all. And he was there for these 16 settling third parties. And that's precisely why what we think the trial court judge did here is appropriate and within the inherent authority of a very experienced trial court judge. This is someone who's seen lots and lots and lots of trials. And what happened here over the course, and this is long litigation as well. And don't forget the long history that the record reveals here. THI and THMI had been represented for years. And then representation was withdrawn. Suddenly, after this 2012 agreement, attorneys reappear saying they represent Trans Healthcare Inc. Now at trial, someone else comes in and says, I represent the receiver. And we know from the testimony that the receiver's the face of the defense, that he's only there as a delegee, that all of these defenses, the defense of THI, has been assigned to someone else, and that they're paying for it. Taking all those facts into account, what the trial court judge did is what more than what one reasonable judge would do. Some reasonable people have actually stricken these defenses and found a fraud on the court. And so we would urge that this court affirm what the trial court did below, as we think it's within its inherent authority. Thank you.
Thank you, Mr. Cruz.
Your Honor, I'd like to correct a number of things that were said. First of all, counsel says that repeatedly said that the receiver testified that the defense was being provided for the settling parties. There is no such testimony in this record. The estate attempted to elicit such testimony but the response was that the settlement agreement speaks for itself, and no one ever testified that this defense was being provided for the appellants, being paid for them, being controlled. There was no such testimony at all. And we cited the pages in the Ventas papers showing that. Counsel also said that the defense did not object when the settlement agreement was mentioned, and that's just simply incorrect as well. There was a vehement objection beginning at pages 430 and 31, 436, 440, and 444. In fact, there was a standing objection granted by the trial court to any mention about the settlement agreement, and there was a motion for mistrial based precisely on the fact that this had not been made an issue in the case. Counsel said that there was no objection to this. Again, look at page 476 where counsel objected that no alter ego or corporate issues had been pled, and cited this court's decision in the Langworthy and Associates case, which is the case that I cited to the court earlier. So there's no testimony that supported what the trial judge did. The only thing that was, other than this statement that there was testimony, the only other thing that is cited in the motion itself is the settlement agreement. And there is nothing in that settlement agreement that does any of the things that counsel has just said, and that's, Judge Kuzan, why he couldn't point you to a provision saying that. There is just nothing in this settlement agreement that in any way purchases a defense. He points to, and I want to walk through the provisions because it's important. Section 3.2 is a provision that assigns claims that the estate has against third parties, including the Wilkes McHugh firm. It doesn't have anything to do with providing a defense in this case. 9.1 is the provision by which one of the appellants agrees to provide certain defenses, and another appellant agrees to pay certain of the defense costs. Section 17, but there's a specific provision in that Section 9.1 that says the settling party shall not have any obligation to pay any judgment, damages, award, or penalty entered against the estates. Now, counsel said that the appellants, use the word, opted out of that provision, went by Section 17, which is the provision that specifically says that none of the appellants, other than the two named in 9.1, will have any obligation to the receiver or to the estate or THI. Section 17.1 paren I doesn't opt out of that provision that the parties will have no obligation. It specifically says that none of these appellants, quote, shall have, well, it says that none of them shall have no obligation to the receiver pursuant to Section 9. They'll have no obligation. It doesn't say they're opting out of the rights that are afforded under that section. So, Judge Kazan, the answer to your question is there is nothing in this settlement agreement that purchases a defense of THI. There's nothing that makes any of the appellants, other than two of the specified ones, obligated to pay defense costs, and there's not a shred of evidence in this record that anybody else did pay any of those or in any way controlled the defense. You repeatedly, Judge Kuzam, asked counsel why notice couldn't be provided and an opportunity to be heard. It's not just notice, it's an opportunity to be heard. And clearly there was no such notice. Counsel for the estate has been dealing with counsel for the appellants in multiple lawsuits over the years. The estate's counsel well knows who that counsel is. It would have been a simple matter to have provided a notice to them and to have asked for an opportunity to be heard. And counsel specifically urged the trial judge in the letter he sent not to have a hearing. And he cited cases that purported to say that the court could add these appellants to the judgment without notice or without a hearing. And the cases don't say that. There's no case that says that. Even the California cases that counsel has cited only allow, under a very specific procedure there, to have counsel, to have a non-party added after there's been an evidentiary hearing and a finding of alter ego. Judge Casanova, you asked about what the issue at trial was, and as you understand, this was on a default of liability. And this settlement agreement, you need to understand, was entered into long after that default order was entered. And so the only issue at trial, and this is a point that the estate's counsel repeatedly made at trial, was that the only issue was damages. And there were no other issues because everything else had been defaulted. And so the sole issue that was tried in that case was what is the amount of damages. There were no instructions on alter ego, no verdict on alter ego, nothing of that sort. It simply was not an issue. And as I've said, when the estate attempted to present evidence of, and successfully, of the settlement agreement, it was over a standing objection and a motion for mistrial. Now, counsel has also said that it was a ruse that the receiver was there. Well, it wasn't a ruse at all. The receiver was there under an order that appointed the receiver to protect the interests of the estate. And that's all that order did. The order only allowed the receiver to appear there to protect THI. And that's what's done when companies go into receivership. The receiver is appointed, and was specifically said that the receiver could have the same authority to represent THI as its directors and officers would have. So the receiver is simply there in the place of the officers and directors of THI, and nobody was in any doubt as to why the receiver was there and who the receiver's counsel was representing. At page 23 of the transcript, the receiver's counsel, and I should, before getting to the problem, I urge you to look at the notices of appearances in the trial transcript, because you will see there that the counsel enters the appearance as the counsel for THI. And at page 23, the receiver's counsel says there's one company that's on trial, and that's THI, and it's represented by the receiver. And the trial court referred to one of the, at page 52526, referred to one of the receiver's attorneys as, quote, counsel for THI. And the estate's counsel referred to him as counsel for THI at transcript 526. So there is no ruse, there was no abuse of process by the receiver being there to represent the interests of THI, just as if the officers and directors were sitting there. Counsel says that equity allows this to be done. If this court should send it back, that the trial court could just use its equitable powers. Well, that's not what this court has said. This court has been zealous for decades in protecting non-parties from being added to judgments when they have not been served with notice, not sued with process, and not had an opportunity to be heard. And we've cited numerous cases that so hold. The state has cited no Florida case that has ever allowed something like this to happen. And we ask the court to reverse and quash and this amended judgment that adds appellants to it and makes them judgment debtors. Thank you.
Thank you, Ms. Walball. Thank you all. Thank you for coming out this afternoon. With that, we're adjourned.
Very nice.